Calling case number 2401173 SM. This is the people of the state of Michigan versus Len Derek Tyler Stringer. Mr. Angot, do you wish to place an appearance on the record?
Judge John Angot, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date, you did knowingly make an open or indecent exposure of your person.
Buckle up, guys, because right from the jump, the tension hits hard. Melly walks in like he owns the room, while his defense team plays it cool. But the real eye-opener? The way Bortlen, his co-defendant, can't seem to keep a straight face. As the judge enters, that courtroom turns ice cold. Everyone knows, this isn't just another hearing. This is where narratives clash and reputations crumble.
The statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters so that Mr. Stringer's presumption of innocence under the constitutions of Michigan and the United States are preserved.
Sir, excuse me, sir. You have not talked to my...
And that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this manner. That's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public. In that regard,
All right, guys, watch this closely. As prosecutors start laying the groundwork, it's clear they're not just building a case, they're building a story, one that paints Melly as cold, calculated, and dangerous. And what's Bortlen doing? Looking everywhere but at Melly. The body language between them speaks louder than any testimony, and if you ask me, the jury's already picking up.
The court would first hear from Detective Keith Baringa of the Royal Oak Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Thank you. He currently has 2 warrants out of the state of Texas for assault and also in assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member, impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying information or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current.
Okay, guys, here's where it gets wild. The prosecution drops details from cell tower pings, car movements, and social media DMs, and you can almost feel the defense stiffen. Melly leans back, expression blank, but that's not confidence, it's strategy. Meanwhile, Bortland's attorney keeps glancing at the jury. Something's not sitting right. This is chess, not chess.
Cases out of Michigan I'm aware of. His criminal history. He has assault from 2019 out of Parkwood Woods, which looks like it was deferred as assaulting a public officer or obstructing, where he got served 9 days ago. And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Royal Oak or parks, grass areas adjacent to it. Or have that.
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court pretrial.
Guys, watch this power shift. The defense finally steps in, flipping the narrative. They challenge motive, shake up the timeline, and make the jury question everything. And Melly, he's suddenly engaged, whispering to his lawyer, nodding along. That calm from earlier? Gone. Now he's in it. Bortland, on the other hand, starts sweating. Whatever the defense said, it hit him.
Dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services, and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause, through himself or through any third party, to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak or Berkeley except for court, work, or medical treatment.
Here's where silence screams. Melly stares down a witness who used to be part of his circle, every second loaded with history. No outbursts, no smiles, just pure calculation. Bortland can't even look up. And the jury? They're locked in. It's no longer about what happened. It's about who they believe. And right now, nobody's looking in.
At this time, there will be 2 ETGs per week for control alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000 cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on right now?
I'm sorry, sir.
I'm being charged. I'm being charged with entity that is.
Can you please move up so the court could hear you?
This is the part that chills you. A clip resurfaces, Melly rapping about murder on my mind. Played in court, it lands like a bomb. Jurors freeze. Defense scrambles to frame it as art, but the prosecution, they lean in. They want that line. Burned into memory. And Melly? He stares at the screen like he's watching someone else. That one moment might have just...
Three.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunutko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lynn Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunutko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Mount Lewis, have you provided discovery to Mr. Sunutko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So yeah, it sees that he was provided with written discovery on June 26th.
okay, so Mr. Sunutko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail.
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the
experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mount Lewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunutko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunutko. I remain unconvinced to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What label, excuse me,
For a competency evaluation.
what labels me incompetent?